Today the theme of our discussion is the powers and functions of the Indian President. At the head of the Union Executive stands the President of India. As we all know that India is a democratic republic. As such, it has a democratically elected government. The head of the state in India is neither a nominated representative nor a hereditary monarch, but an elected representative of the people, even though the election may be an indirect one. The President of India, who happens to be the head of the state, is elected indirectly by an electoral college, which is composed of the elected members of the parliament and the state legislature. He or she is elected for a fixed tenure of 5 years. Under Article 52 of the Indian Constitution, the executive power of the Union government is vested in the President of India, who is empowered to exercise it either directly or through his officers subordinate to him. The President of India is at the head of the executive power of the Union government. Now, naturally, a question that creeps in our mind is, what exactly is meant by the executive power? Broadly speaking, by executive power, it is meant the execution of the laws enacted by the legislature. However, with the passage of time, the very notion of the executive power has undergone a severe change. In fact, over the years, with the expansion of the activities of a modern state, almost all the residuary functions have been passed into the hands of the executive. The ambit of the executive power has been explained by the Supreme Court in the famous case of Ram Javaya versus State of Punjab that took place in the year 1955, whereby it was stated that the executive power covers both the determination of policy as well as governance of the general administration. Viewed from this perspective, it seems that the President of India has supreme authority so far as the executive power is concerned. The powers and functions of the President can broadly be classified into two broad heads. Firstly, the normal powers and functions, and secondly, the emergency powers. Today in our lecture, we will be concentrating solely on the normal powers and functions of the Indian President. The normal powers again can be classified under the following heads. They are, first of all, the executive power, the legislative power, the financial power, the judicial power, and the miscellaneous power. We will be taking up these powers one by one and analyze it further. So first of all, we will be discussing the executive powers of the Indian President. As being already stated, the President is the chief executive of the Indian administration. The executive power of the Indian President can be enumerated in the following manner. Firstly, the entire administration of the nation is carried out in the name of the President of India. Not only that, almost all the major decisions are formally being taken by the President. He makes rules of business whereby the activities of the Union government is to be conducted, and at the same time, he also allocates works amongst the ministers. Secondly, the President is likely to be informed by the Prime Minister with regard to the administration of the Union government. In this respect, the President may even ask the Prime Minister to submit a report or submit the decision of a minister concerned over an important issue. He or she may even request the Prime Minister to reconsider the decision if he or she so desires. Thirdly, several important appointments are made by the President. That includes the appointment of the Prime Minister, appointment of the other ministers, the Attorney General of India, appointment of the Comptroller and Auditor General, and so on. Besides this appointment, the President may also appoint the chairman and other members of the important commissions or statutory bodies like the Union Public Service Commission, the Finance Commission, the Election Commission, and so on. Being the appointing authority, the President has also the power to remove a particular officer who is appointed by him on a particular occasion. As such, he may remove the judges of the Supreme or the High Court, or even the members of the Union Public Service Commission on the basis of a report submitted to him by a judge of the Supreme Court. Fourthly, the President is the sole administrator of all the union territories and the tribal areas. Every union territory has an administrator who is appointed by the President of India. The President may even entrust the administration of a neighboring union territory to a governor of a state, whereby the governor is required to act on the decision or act on the directives issued to him by the President, and not on the advice of either the Council of Ministers or the Chief Minister of that state. Fifthly, the President, by virtue of being the head of the state, maintains the foreign relations. All the diplomatic business of the nation is conducted in the name of the President of India. Sixthly, the President is also the supreme commander of the defense forces. He appoints the chiefs of the Navy, Army, Navy, and Air Force, and also he is the head of the National Defense Commission. On the basis of the decision taken by this important commission, the President may even declare either a war or peace against another nation. Seventhly, the President is empowered to make laws over certain important subjects like the joint session of the Parliament, the appointment of the officers in the Supreme Court, the administrative power of the Comptroller and Auditor General, and so on. Finally, the President has the power to issue directives to the state government on the basis of which the administration of the state is to be carried on. This power enables the President to exert its control and supervision over the states. If any state government refuses to act on the basis of the directives issued to it by the President of India, then the President may even impose Article 356 and take the administration of the state in his own hand. Like the British monarch, the Indian President too is an integral part of the Parliament. The legislative power is nothing but powers which are supplementary to the other powers assigned by the Constitution of India. The legislative powers for our convenience can be discussed in the following manner. First of all, the President is empowered to summon and prorogue the session of the Parliament. However, the President has to take note that the interim period between two sessions of the Parliament shall not exceed the tenure of 6 months. The President is also empowered to dissolve the Lok Sabha. In case of a deadlock situation between the two houses of the Parliament, it is the President who can call a joint session whereby he is required to make the rules of transaction of business therein. Secondly, the President may appoint 12 members to the Rajya Sabha from amongst persons who are eminent in the field of art, science, literature, or social service. He may also appoint 2 members from the Anglo-Indian community if he feels that they are not adequately represented in the Parliament. Thirdly, the President may also give his lecture. The President is empowered to address or to send messages to the Parliament. the first session of the Parliament after the general election, and the first session of the new year begins with the inaugural address of the President of India. The President may send messages to the Parliament with regard to a particular bill pending or otherwise. Fourthly, a bill cannot become an act until and unless the President gives his or her assent to them. The President has sole veto power over the bills passed in the Parliament. When a bill is passed in the Parliament, the President can either give his assent to it, withhold it, or send it back to the Parliament for reconsideration. If the bill is passed for the second time in the Parliament, accommodating presidential recommendations or not, but for the second time the bill cannot be withheld by the President of India. At the same time, it must also be noted that the President does not have the power to withhold a bill if the bill happened to be a money bill or constitutional amendment bill. Fifthly, when the Parliament is not in session in a situation of special necessity, the President may promulgate an ordinance that shall have the force of law. The ordinance can be withdrawn by the President at any point of time, but it shall cease to have its effect after 6 weeks. Sixthly, the President shall cause to be laid before the Parliament the reports or the recommendations of the various commissions like the Finance Commission, the Election Commission, the Official Language Commission, the Union Public Service Commission, and so on. Seventhly, the President has sole veto power over the bills that are passed in the state legislature. The bills, when it is passed in the state legislature, some of the bills passed in the state legislature can be reserved by the governor of that state for the consideration of the President of India in case the bill found to contravene the existing union legislation or if they are regarded as essential by the Parliament. In case of such bills, the President may either give his assent, withhold it without assigning any reason, or may send it back after consulting the Council of Ministers or the Supreme Court of India if he so desires. Finally, the President of India has the power to direct by a public notification that from such and such date as specified therein, state laws or union laws shall not be in force in major part of the country or shall be in force with minor alterations or modifications as specified in the notifications therein. The financial powers of the President of India includes the following. First of all, no money bill can be introduced in the Parliament until and unless they have the prior consent of the President of India. Secondly, the Consolidated Fund of India is at the disposal of the President of the country. He can make advances out of it to meet the unforeseen expenditure. Thirdly, the President shall cause to be laid before the Parliament the annual financial statement of revenue and expenditure, more popularly known as the budget or supplementary budget, for its approval. And finally, the President is also empowered to determine the state share of the income tax and amount of grants in aid to certain eastern states in lieu of their jute export duty. Now let us examine the judicial powers of the President. The judicial powers of the President constitute his prerogative of mercy. The President can pardon an offenders, remit, suspend or commute their sentences in 3 major cases. These 3 major cases are, firstly, where the punishment is given by a court-martial; secondly, where it is for an offense against a law relating to a matter to which the executive power of the Union extends; and finally where it is a sentence of death. Now the miscellaneous powers of the President. The President of India enjoys certain miscellaneous powers which for our convenience can be discussed in the following manner. First of all, the President may refer a question of public importance to the Supreme Court for its opinion. Secondly, he may make regulations determining the number of the members of the Union Public Service Commission, their tenure, terms of their service, etc. The third miscellaneous powers is regarding the official language of the nation. Though the use of the English language as the official language has been retained by the Official Language Act of 1963, which was later on amended in the year 1967, the President can also authorize the use of Hindi for the official purpose if he thinks it to be fit and is required. The President of India may also appoint the Official Language Commission from time to time for their recommendations over the issue. Finally, the President has some very important role or some very important powers with regard to the state of Jammu and Kashmir. The President may issue orders for the extension of the provision of fundamental rights or the extension of the jurisdiction of the Supreme Court or the jurisdiction of the Election Commission. The President also enjoys his prerogative of mercy so far as the state of Jammu and Kashmir is concerned. So a thorough analysis, a thorough understanding of the powers and functions of the Indian President reveals that he is the supreme power in the field of administration. However, there are certain constitutional limitations under which the President of India has to exercise his powers. First of all, the President of India has to act on the provisions as laid down in the Constitution of India, and this is in accordance with Article 53, Section 1 of the Indian Constitution. Article 75, Section 1 of the Indian Constitution explicitly states that the President can appoint minister apart from the Prime Minister on the advice of the Prime Minister. If the President appoints any persons as a minister from outside the list provided to him by the Prime Minister, then the President is even liable to be removed from his office by the procedure of impeachment on the grounds of violation of the Constitution. Secondly, Article 74, Section 1 of the Indian Constitution clearly states that the President, while exercising his function, is required to act on the advice of the Council of Ministers headed by the Prime Minister. Prior to the 42nd Amendment Act of 1976, the President was not bound to act on the advice of the Council of Ministers headed by the Prime Minister, though it was judicially established that the President has to act in accordance with the advice of the ministers. But so long as they enjoy or so long as they command the majority, absolute majority in the Parliament. But the 42nd Amendment Act made it obligatory on part of the President to act on the advice of the Council of Ministers headed by the Prime Minister. So, the President of India, as being already stated in the exercise of his functions, is required to act on the advice of his Council of Ministers headed by the Prime Minister, a refusal of which may result in the removal from his office by a process of impeachment on the grounds of violation of the Constitution. Thank you.